I'm Johnston Clark and I'm going to speak to you today about how to challenge a will in Scotland. This is not about how to correct a will where there's been a mistake made by someone paid to prepare it. That procedure is called rectification, and that's a different matter. You can make a valid will in Scotland from the age of 12. In Scotland, there are 5 grounds for challenging a will, and I'll talk through what these are today. When someone talks about challenging a will and overturning it, in Scotland we call that reduction. An action of reduction can be raised in a sheriff court, and the person who raised the action, who has tried to overturn the will, is called the pursuer. Before I talk about the grounds for challenging a will, I should mention a few practical points which might affect your decision to pursue a challenge. Although an action can be raised in the sheriff court, and this is a lot cheaper than raising a court action in the Court of Session, the question of cost does arise. Even though expenses often, but not always, follow success, the person challenging a will rarely recovers all their legal expenses, even if they win the action. Normally, I would suggest you'd be lucky to recover half your costs. It also follows that if you lose an action in the sheriff court, and challenging wills is a risky business, as we'll see, you might end up with the expenses of your opponent. Losing a sheriff court action which goes the distance can cost you £30,000, so it's very important that you keep things in proportion and not let principle guide your decision on its own. Another important point to remember about challenging a will is that you cannot pick and choose the bits of the will which you dislike and want to change. If a pursuer succeeds, the whole will is cancelled as if it had never existed. It's important to know that since 2016, a previous will does not revive in these circumstances. These have often been destroyed anyway, so you can find that winning an action leaves you with the statutory scheme under the laws of intestacy in Scotland, and they don't always produce a result that you would anticipate. The last thing to remember is that the standard of proof required is what we call balance of probability, and that means more likely than not. So even if you think it's obvious that someone has been at it, the proof still has to be achieved to that standard in court. The person who's made the will is deceased, and unless there are, for example, diaries or letters left, the deceased's evidence will not be available at all. So, turning to the grounds for challenging a will, the first of these is fraud, and a good example of fraud might be deceiving someone into making a fresh will. The next ground for challenging a will is to prove that the person writing the will was incapable at the time he or she made the will. Capacity is a legal matter, it's not a medical matter. Capacity can come and go. It also refers to the subject matter, so whilst a person might understand a simple will, they might not be able to understand more complicated arrangements, for example, setting up trusts. Medical evidence will certainly be required. When looking at capacity, one can see people who have signed wills who are registered blind. Being blind does not in itself make a will invalid, and the law allows a blind person to sign him or herself, or for what we call a relevant person, for example, a notary public, to sign on his or her behalf. The next ground is what we call facility and circumvention, and that means what it says, that a person is rendered facile mentally and is got around. Facility is not necessarily a permanent condition and can be brought on, for example, by bereavement, but it is necessary also to show the circumvention. Medical evidence will probably be required here. Solicitors are trained to look out for evidence of this, for example, adult children attending with elderly parents to make wills in their own favour. The last ground, which is often pled with facility and circumvention, is what we call undue influence. Influence itself is not necessarily struck at, and we would often see the person writing the will consulting with other family members when making it. Undue influence, however, implies a relationship and some kind of force or threat. For example, someone making a will being told that if the house is not left to the son who lives there, he will put her in a care home and never see her again. As you can imagine, this is just an indicator of the sum of issues which arise when wills are being challenged. Challenging a will is not an easy matter, and court actions are expensive and stressful, win or lose. It's always best to take professional advice before setting out on such a course, and the team at Blackadders would be happy to talk to you about any of the issues you may have and which are discussed here.